mean, there are jurisdictions across the globe that don't use juries at all, where they let judges decide the entirety of the case. I frankly am partial to the jury system. I think that the jury system is a good check on governmental overreach, but juries are unsophisticated and they're surprisingly dense. They don't understand the law the way the attorneys do. And some might say, well, the attorney's job is to help them understand the law. And I agree with that, but it's quite difficult to impart a concept like proof beyond a reasonable doubt standard to a jury who's never really grappled with that topic. And frankly, attorneys mess it up all the time. Here in Arizona, we have an instruction on how proof beyond a reasonable doubt works called the Portillo instruction, because it comes from a case called State v. Portillo. And what it says is that very few things in this world can be proven beyond all doubt, and we don't require the state to prove their case beyond all doubt, just beyond a reasonable doubt, and that if the jury is left firmly convinced of the defendant's guilt, then they must find the defendant guilty. However, if they feel or find that there is a fair possibility that the defendant is not guilty, then they must return a verdict of not guilty. And what I have seen happen in pretty much every trial I've done in front of a jury is that the state's going to really lean on the whole, we don't expect the state to prove anything beyond all doubt. And as long as you're firmly convinced, they will talk about that part of the instruction. And then the defense attorney gets up and talks about that latter part of the instruction, talking about how if there's a fair possibility that the defendant did not commit the crime, then you must acquit him. And it's silly because it's all part of the same instruction. And the instruction itself is confusing. It's worded in a way that is it's filled with double negatives, and it's just not a clear instruction. And I think that's by design. I think we don't want to give juries that kind of clarity. I don't really know why, but we don't. And juries are often left to sort of guess how they think the standard of proof beyond a reasonable doubt works. And it's uncomfortable. So that's how hung juries work, and how the requirement of unanimous verdicts works. And it's a strange quirk. It's a strange quirk of our system. It doesn't have to be that way, but it is that way, and it's been that way for quite some time. But it could change. It's not going to change anytime soon, though. Part of my frustration is tied to the fact that here in Arizona, they took away our peremptory challenges, which is a strikes without cause. In most states, I think pretty much every state for now, except for Arizona, the process of selecting a jury is such that, yes, you strike jurors for cause, meaning you say why it is that the juror is not qualified to serve on the jury. And if you persuade the judge that that is correct, then the judge will strike them and they go. But then there are peremptory challenges where you can just strike jurors for any reason you want or no reason at all. And that's a way of getting rid of the jurors that give you the feeling that they're not going to give your client a fair shake. And here in Arizona, they did away with that. They claim it's because they were tired of dealing with the litigation about whether or not people were excused from juries for improper purposes, which would basically be race or gender, which is not allowed under the Constitution. But people were apparently striking jurors for those reasons and then claiming or I should say race neutral or gender neutral reasons, which is the way the process is meant to work. But the state Supreme Court here in Arizona decided they didn't want to play that game anymore, so they just did away with peremptories. It's a very stark example of throwing the baby out with the bathwater. And so now we end up with this jury selection process where you have to try your darndest to really get to know those jurors before they are sworn in on the jury, and to try to develop challenges for cause, which is quite difficult. In this last trial, I had people on the jury that I would have never dreamed of having on this kind of jury for this kind of case, but there was no way to get them struck in for cause because they said they'd be able to be fair and impartial. And when I explored the things that I thought would make them unable to do that, they answered the questions in the right way. Not necessarily in a truthful way. There's really no way to tell if the jurors are telling you the truth. But if they say the right words, judge isn't going to strike them because they said all the right things. So it's a strange thing to get a hung jury. This was my first hung jury. Actually, I've always gotten a verdict when I've tried a case, except for this time. And among criminal defense attorneys, it's understood that a hung jury is the second best result, right? Because it means your client is still innocent. And in this instance, my client got to go home, got to sleep in his own bed, and it's going to be a few months before we try the case again, if at all. So it's a good outcome, but it didn't feel like that because, frankly, I was tired. This was a 2-week trial, and to try it again, I'm already kind of sick of it. Like, it's kind of like eating the same thing for 2 weeks, and then someone says, "Hey, here's more," and you're like, "I'm done with it. I've had enough." So part of the challenge is going to be to get excited about this case again, which I'll be able to do. And once we have a new trial date, if that's what's going to happen, I'll be prepared, and I will certainly try it differently. I won't be reserving my opening this time, and we'll come up with new things to say to the jury to hopefully persuade them to acquit my client. Anyway, that's how it works. If this surprised you, if you know that things work differently in your jurisdiction, if you have questions about this, drop them in the comments.